world. It's very early in the morning here in British Columbia on the west coast of Canada, and it's 8:30 in the evening, if I'm not mistaken, for our guests who are joining us from India. And I think there are people from other places too, so I can only imagine all the different time zones. My name is Kevin Hanna, and I'm a professor in earth sciences at the University of British Columbia. And I also have the pleasure of being the director of the Centre for Environmental Assessment Research at UBC. We're joined tonight by Dr. Shrestha Banerjee and Dr. Rajesh Shada, and the title of our talk of this session is Environmental and Social Licenses for Mining Projects in India, Assessing Regulatory Gaps and Prospects for Reform. And I want to thank everyone for joining us. This is an important and significant exchange of knowledge, of information and understanding from different jurisdictions at different parts of the world on how the mining industry is affected by different aspects of social expectation, cultural, economic, and other dynamics that we sometimes forget in the industry but are essential and important. So the objective of our session today is to share research from Canada and India with regard to environmental assessment and regulatory regimes with a lens on the challenges, the constraints, and opportunities for supporting well-functioning environmental impact assessment processes in a national context. I'll be the moderator, and at the end of the sessions, we will have an opportunity for questions. So people will use the chat function to pose their questions. I may not be able to get through all of them. I apologize for that in advance. So I will be picking and choosing selectively, which gives me an awesome power to find those questions that I think are really interesting and cool and pose them to our guests. But I do encourage you that if there's something you wanted to follow up or talk about after, to please feel free to contact Brookings India or CIRDI here in Vancouver. So I think with that, I'm going to move over to our guests. And the order is that Dr. Rajesh Shada will begin. He's the Program Director for Natural Resources at Brookings India. Excuse me. He was formerly a professor and research director at the National Council for Applied Economic Research in India. And we're honored to have him join us this evening. And then Dr. Shrestha Banerjee will join us. She is a visiting scholar with the Natural Resources, Energy and Sustainability team at Brookings India. She's an environment and public policy expert. She has over 10 years of professional experience in research, policy advocacy in India, excuse me, and in the United States. So we have a collection of remarkable expertise joining us this evening. So at that, I will stop and I will turn it over to our first speaker. So Rajesh.
Thank you very much, Dr. Hanna, for your very kind introduction. And this event has been made possible. A very brief couple of minutes background to this. First of all, our sincere thanks from Brookings India to the Canadian International Resource and Development Institute, CIRDI, at the University of British Columbia for inviting us to speak at this webinar. Thanks are also due to Ms. Olena Soldatova for all the effort in connecting with us. We are grateful to Professor Kevin Hanna for agreeing to moderate. You see, the relationship that began, this relationship with CIRDI and Brookings India, is commenced in February. It's very recent actually, just pre-PDAC conference, February 2020, when Mr. Andrew Smith, Minister Commercial, and Mr. Saibal Ghosh, Trade Commissioner at the High Commission of Canada in India, introduced us to Dr. Priya Bala Miller, Director of Partnership and Program Development, CIRDI. This was just before I was to leave for Toronto to attend the Prospectors and Developers Association of Canada, PDAC 2020 convention held in the first week of March. It was good to meet Dr. Jamie Webb there, Mr. Ben Chambers of Mining Association of Canada, and Mr. David Williams, Trade Commissioner, South Asia. So it turned out to be a good experience to interact with these people there. And this later we were told that it will be good if we can share our and exchange our notes. So what I will be doing, very briefly introducing why what we are doing today is important. Brookings Institution India Center started, there is a vertical called Natural Resources and Energy, where the research on coal and oil is already on, but non-fuel minerals work started September last year. And what we are doing in this, I'll be very brief on this research agenda that we are working on, deals with the comprehensive techno-economic analysis of non-fuel minerals. I am an economist, so I would talk a little bit in economics terms. We thought that we will be doing 3 separate parts in our research program, which runs for 2 years. One is the positive economics, that is, what is the status of efficiency mining activities in India. The second one in between, if you can see, is the international good practices, because I don't know what the best are. I termed it as international good practices. What are the learnings from other mining jurisdictions? And thirdly, the topic of the day today, normative economics. What are the externalities and what ought to be done? In the case of positive economics, for those who will be interested in contacting Brookings India, we will be talking about the mining opportunities for profits and growth. Operations have backward and forward linkages through input-output modeling structure. Efficient firm level operations add value to the overall growth of the sector, which we need very urgently in India. Efficient supply operations add to the competitive advantage of the mining firms. So we are looking at all the 4 aspects, and you can visit Brookings India to see that some of it is already published as the blogs. So what we are doing is multiple things: exploration, the issues involved for India; allocation, where it is how the mining contracts get awarded; extraction, regulation, royalties, logistics, trade policy, and public versus private players. What we are doing also, as I said, international good practices. We are trying to learn from these jurisdictions currently. Australia and Canada are the 2 advanced economies that we would like to learn the good practices in mining from. And within developing economies, we'll be doing more, but at the moment, what we will be looking at, which we have to start: Chile, Mexico, Brazil, and South Africa. Normative economics, which is actually the part of the story today, involves multiple things, where we look at the environmental issues, local communities. These are the 2 important issues for the day-to-day, apart from wildlife and forests. Cooperative mining at all, if we were to look at sustainable development goals and mine closures. Finally, there is one more slide that I think I would like to show, and then I would be speaking for another couple of minutes before I pass it on to my colleague. Environment and social licenses, regulations, and the way forward. What we had in mind when we were charting this program is that we need to look at environment, forest, wildlife, pollution board clearances, then social license for ensuring free, prior, and informed consent, environmental, public hearing, and Gram Sabha. Gram Sabha in India is village council, consent for forest land diversion, not effective at times. So whereas environmental and other clearances are time consuming, the other set of clearances are not effective at times. And I'll give Shrestha an opportunity to speak on this, that, how the legal cases tell us that some of what was promised was not done. Reforming the way forward, or the way, so environment and social impact assessment needs to be in the form of integrated reports rather than fragmented ones. Sustained community engagement early on. This is a topic that we have been thinking. We have not yet started work on this. That is, clean mining, making public consultation process more effective. that is continued engagement, not just at the time of post-peace, and ensure compliance. I am stopping my PowerPoint here, but I just want to add a few important issues that confront the mining industry for the issues that we are discussing today, that is forests, environment, local communities. The environment and forest clearances, as I said, they are multiple layered, fragmented, takes a lot of time, which will come to you in a few minutes now. Social license that we are going to talk for those who, most probably many of the people in the audience would know, but social license refers to approval and acceptance of the local communities for mining activity in their region, and granting of the social license for development project, whether it is mining or another one. Mining is, a little more polluting, so including mining is part of the clearance and permitting mechanism. This includes public hearing, consultation for environmental clearances, forest rights settlement mechanism for forest clearances, and Gram Sabhas are an important part of it. The government has already started with a single window scheme. Details I leave for Shrestha Parivesh. What I think is important, and that is what I made my notes on when I was in PDAC conference in Canada very recently, that the issues that Mining Association of Canada has been discussing, the 10 principles and responsible mining, I think are important. And we do have, by the way, Sustainable Mining Initiative, SMI, under the Federation of Indian Mining Industries, FIMI. And I'm glad that it has got something, the aim is something similar to what the Mining Association of Canada or ICMM does. That is the overarching aim of SMI, that is Sustainable Mining Initiative of FIMI, is to promote the tangible and measurable concepts of sustainable mining, assist the mining sector to inculcate sustainable practices in mining operations, and tackle the industry-wide challenges. Lastly, what is important is that instead of being a one-time clearance for the social license, the National Mineral Policy 2019 has mentioned that an endeavor to auction mineral blocks with pre-embedded statutory clearances. So our view is that there should be a continuous process that the government should be engaging with the potential mining jurisdictions, so that it's not those 45 days or 50 days or 60 days in which the local community gets educated. It should be, if it is the responsibility of the mining companies, it is also equally the responsibility of the government to be engaging with the people in general, even before the leases have been granted. I think I'll stop here, Dr. Hanna, and give it back to you.
Thank you very much. I'm going to go to our next guest this morning and invite her to begin her presentation. Shastra, please.
Thank you, Kevin, and thank you all for joining, actually, those in Canada, and I know some people joining from US as well. A very good morning to all of you, and those joining from here, a very good evening. First, before I go into the presentation I have put together, I just want to mention, actually, I think this topic comes at a time when mining is a very hot issue, particularly in India. And it is for the reason that we are, in our generation and in many of our generations, we are going through an unprecedented crisis, which none of us thought. And how to come out of that crisis, which is a big economic crisis as well as beside the health crisis, people are looking into ways. And in India, as the government is considering various mechanisms to get out of this crisis, one of the key sectors actually is the mining sector. It involves both coal and non-coal minerals. So And this, in fact, the idea is to ramp up production in both coal and non-coal, basically to boost the country's domestic production, reduce imports, boost other sectors, because mining, I believe, is, when I started working on mining, I'm not an engineer or a mining person, I was an environmentalist, and I work on social and environmental issues, but it is one of the most complex sector which has to do maybe with everything, and every sector that you think of has to do with mining. Even if we talk of renewable energy today, it will require some amount of mining. The power sector, everything. So the point is that it is going to be there. I believe, as even from my environmental standpoint, that we cannot wish away mining. But the question is that how do we reduce the externalities, because that has really been the hot debate and one of the key governance issues over the years. So I'll start with that. And once again, thank you, UBC and CD, for organizing this very important seminar. So basically, if we consider the mining regime of India, it is quite complex, the regulatory process in mining in India. And if I broadly divide it, it comes into 4 components. It has to do with the granting of mineral concessions on permits, which is largely dealt by the Central Ministry of Mines as well as the state government mining departments. Then there are issues of mineral conservation and development, for example, that involves preparation of mining plans, proper mine closure practices, optimum utilization of resources, how much can be mined and all that, which is under the Indian Bureau of Mines, which is an expert of the Mines Ministry. Then there are the questions of green clearances and permits, basically which have to do with environment and forest related issues. Fitly so, it comes with the Ministry of Environment, Forest and Climate Change. It is a nodal agency to deal with these mechanisms, and the allied agencies. But then there is also the state and the district authorities which have to play a role in it. We'll come to that. And finally, there is a very important component of displacement and rehabilitation issues that the mining sector or the mining governance has to deal with, which involve the state government, the district level administration, and most importantly, because it's very local issue, it involves our local level governance institutions, such as what in Indian terms we know as the Panchayati Raj institutions, where comes the village council that Chadha was referring to. Now, first question that I would like to say, that why is it environment and social component has been such a important topic when it comes to mining governance over the years, and even today when we are thinking of scaling up mining, why it is one of the issues really we need to think through. For when we look at even global best practices and we compare it to India, one of the things that India has unique is, and I call it a unique contested geography. Because if we look into the mineral map of India, the mineral bearing areas also have some of the best forest land, the richest forest habitats of this country, water bodies, as well as some of the poorest and marginalized people who actually are deprived, high poverty, and they have very little knowledge of their rights and entitlements under most of the laws. So there comes a clear, that's the reason that there has been a clear recognized necessity to protect the environment as well as the community interest for any developmental activities, and particularly mining projects, because mining projects typically has this critical overlap. So basically, this environmental and social licenses processes have been brought in. What this process does, it gives the scope to assess what will be the impact of a project on the environment as well as the community. And this impact is very broad. So it involves pollution impacts on air, water, soil. It has impacts on forest land diversion, alteration of ecological habitats, wildlife habitats. It has an impact of human health, because pollution is very closely related to human health. It has impact on livelihood loss, because pollution has a relation to loss of agricultural productivity, land loss, and then there comes the issues of compensation. It has to do with displacement, because when an area is diverted, some people have to be displaced. You go to any mining area, the villagers living close to the mine knows that when the mine will expand, they will have to move away. And then it has to do with a lot of migration, because there are distress migration from these mining areas. The reason this environmental and social licenses also becomes important and has remained an important topic, because if we look into the court cases, judiciary had played an extremely important role in environmental governance in India for a long time. And the Supreme Court of India, if we look into the host of cases at the court, and one of the papers right now I'm working on is that, I just finished it. And if we look into also the National Green Tribunal, which is the Green Tribunal of India, if we look into the court cases, a lot of them has to do with, and mining cases in these courts, it has to do with environmental and community disputes. So I always feel the judiciary cannot be the recourse. So we really need to fix the administrative issues, the responsibility of the mining companies to actually improve mining practices in India. Now, the way I thought of sharing my observation on this issue, I'll do it in 3 parts. First, I'll broadly give an understanding of what is the current way that this environment and social license process is dealt with. Then I'll highlight some of the key challenges that I feel, and this has been discussed with many experts over the years, are there. And finally, what can be the way ahead? Because honestly, as policy practitioners, we also need to understand that be it government, be it mining company, or be it the community, everyone finally looks for a solution. So that's what we'll finally arrive at, and I'll proceed that way. Now, when we talk about environment-related clearances and social licenses, since it's so intertwined and it's interlinked, basically the social license mechanism, or a lot of social, community participation, has been inbuilt into the environment or forest clearance processes in India. Basically, if I take the broad clearances, the major ones, there are 4 types of clearances that typically a mining project invites. And there are many small ones. I'm not getting into that. One of the key ones is the environment clearance. And as part of this environment clearance, the community consent part, or the community engagement part, comes as a way of public consultation, or what is called the public hearing, which is basically that the community can voice their opinion about the potential environmental impacts that they think that will have. Of course, the project proponent has to share with them an any draft assessment report on their part, and it should be a consultation process, and the community should be allowed to say that whether they want the project to come up or not. Then there is another major clearance that is required is the forest clearance. And in the forest clearance, there are 2 types of community engagement or social license processes that has been built in. Number 1 is with the consultation with the village council with respect to the idea of forest land diversion. So they must know that why this forest land is being diverted, what is the purpose, and to what extent. The second one is also extremely critical, which has to deal with forest right settlement, particularly of the tribal, forest dependent, and people who live in these areas, forested areas. So basically to safeguard their interest. And that is regulated under a different act, but it is part of the forest clearance process. Then there is a wildlife clearance process, which is required if a mining project involves a wildlife habitat, comes within a specific radius of a national park or wildlife sanctuary, so on and so forth. And finally, there is a set of consent or permits that is required from the state level, state governments, which we know as the pollution control boards in India. And because unless you get that, you do not have a go ahead to start mining. So given this complexity, it's very clear that there are a lot of regulations and subordinate legislations which are involved in this process. And simultaneously, there are a number of authorities. So if we look into and these are all the major environmental legislations in India. The environment clearance process comes under the ambit of the Environment Protection Act and a very important subordinate legislation, which we call the Environmental Impact Assessment Notification, or in short, the EIA notification. The nodal agency for the environment clearance process, as I mentioned earlier, is at the central level. It's the Ministry of Environment and Forest Climate Change. But at the state and district level also, we have the clearance and assessment authorities corresponding to the central government. Then there is the forest clearance process, again governed by the Ministry of Environment, Forest and Climate Change, which comes under the ambit of the Forest Conservation Act, which is a 1980 act, which is in fact one of the very early on legislations. Then there is the Wildlife Protection Act, which deals with the wildlife clearance, and here the National Board of Wildlife comes into the process. And finally, there is the consent to operate, which is basically gives a go-ahead whether the project can be operational or not, which comes under the State Pollution Control Board. And it comes under the ambit of two very important acts which came at the onset of the environmental movement in India, which is basically the Water Act and in short the Air Act. So this is the broad framework of governance. Now, when we look into the clearance mechanism, how it has been dealt with in here, it's quite complex because it's a big country. There are limited capacity of authorities at the various levels. So the clearance process is dealt at 3 levels of the government: at the center, at the state level, and also at the district level. The way it has been broadly classified is that when it comes to environmental clearance, 50 leases with 50 hectares or more are given a clearance by the Ministry of Environment at the central level. But for leases less than 50 hectares, but over 5 hectares goes to the state board, the state authorities. And finally, the clearance of very small leases, which in fact started to get regulated below 5 hectare leases since 2016, has been put under the jurisdiction of the district authorities. But interestingly, when it comes to forest clearance, given the complexity and the importance of forested areas, all the forest clearance related to mining projects are actually cleared at the central level, and so as the wildlife clearance. But there is one unique thing with forest clearance. Because land is a state subject, there is a final authorization letter that has to be issued by the state government after all the clearances have been procured. The consent, of course, lies with the state board. So all three, center, state, and the district, all the governance instruments, the authorities at these 3 levels comes into play when it comes to mining projects. If I broadly, this is for broad overview of how this clearance process then happens, because there are so many authorities involved, so many laws involved. So there is a stage-wise process which comes into play. Though the Ministry of Environment, Forest and Climate Change has developed a single window clearance process where simultaneously the project proponent can file for the environment clearance, forest clearance, and wildlife clearance, but and then they are given a unique code to monitor the progress. But the way it is actually given is, unless a stage 1 forest clearance is granted, an environment clearance can't be granted. So in India here, just to mention briefly, the forest clearance is broken up into 2 stages. First stage, it is largely with the assessment of the amount of forest land diversion, the numbers of tree felling, so on and so forth. After which, if a stage 1, or in principle it is called, it's not a final clearance, is granted, then there are certain conditions that a project proponent has to fulfill, such as providing a money for compensatory afforestation, settlement of rights, so on and so forth. And unless they fulfill those conditions which are granted, which are given at the granting of stage 1 clearance, they will not get a final clearance. And this also involves the settlement of forest rights. Now, after a stage 1 clearance is given, then only a company or a mining agency can get an environmental clearance, so they can be processed simultaneously. And once a stage 1 and forest clearance and an environmental clearance is granted, then only the final forest clearance can be granted. And once all of this is granted, then finally the consent order is given by the state post based on all these clearances. And the mining projects can start. Now, if I stop at this, it seems like, and whenever people who are new to this, a lot of time it seems that it is a very foolproof mechanism. You have some of the best laws of this country working in the interest of environment and communities when it comes to mining. You have a whole lot of authorities starting from the central government going down to the district level when it comes to regulating the sector. And then there are also expert agencies who are advising these ministries on, there are authorities like in Indian Bureau of Mines. But then why mining remains such a disputable issue over the years? And why there are so many issues going to courts in terms of environmental and social consequences of a mining project? If we closely look into the assessment process and closely look into the documents that comes into play when a project is assessed, the entire assessment process is extremely fragmented. Now, if you just look at these 3 clearances, the environment clearance, the forest clearance, and the wildlife clearance. Now, when a mining project comes into play, all these clearances are actually looking into a single set of land. But when the authorities are dealing with its clearances, they require different set of documents. They're looking at different documents. For example, for an environmental clearance, the key document that is relied on is an environmental impact assessment report, which is prepared by consultants, engaged by the project proponents. Now, there are certain quality control issues in that, but that is largely the process. Then there is also an environmental management plan that's simultaneously prepared. There is a mining plan that has to be prepared and pre-approved by the IBM. And finally, the public hearing observations has to be submitted. And there are other things also, but these are the main things that are looked at when a decision on environmental clearance is being made. But when you come to the forest clearance, though we are looking at the same set of area, what the forest committee looks at is completely, they do not have any assessment reports to look at. They look at a lot of site inspection reports, which are actually 5 forms, which are largely prepared by the forest officials based on an initial submission by the project proponent on the detail of the project. They also look into a mining plan, and finally they look into the records of the settlement of forest rights or how it had proceeded. Now, finally, when you come to the wildlife clearance, in cases where it is required, there is no impact assessment report. And while it only makes common sense to have overlap between the forest and wildlife assessment, but what actually happens is that there is a component of biodiversity impact assessment in the environmental impact assessment report, which is considered for the wildlife clearance. And then further, if the National Board of Wildlife thinks that there is need of a more comprehensive assessment report, then only there is a report prepared, or the EAC, the Expert Advisory Committee of the Ministry, asks to prepare a management plan for the wildlife, then it is prepared. But other than that, it only relies on a very small section on the environmental impact assessment report to consider a wildlife clearance on the first go. So basically, if I look into all these authorities, it is quite clear that none of them are looking into one comprehensive set of document when assessing the impact of a project, which is going to impact the same set of environmental, the same area, the same geography, the same forest land, the same communities. Secondly, this is the most curious case, is that while forest areas have been considered clearly even by the administrative authorities as an important issue, and that's why all forest clearance come to the center, but then there is no comprehensive assessment. It only relies, as I said, on 5 set of forms largely, which is filled up at back and forth by various authorities. Finally, the way these documents are submitted and taken forward are also quite interesting, which challenges the accountability. For instance, the EC has to be submitted by the project proponent. The project proponent has to engage an EIA consultant to prepare the EIA report. But when it comes to forest clearance, largely the process is facilitated by the state governments. So the district officials, the divisional forest officials put forward slowly the paperwork to the government authorities for a clearance. So there is a difference, and the main problem happens, this very well comes out in court cases, that when you have to hold someone accountable for some wrong assessment or some dispute, then it goes on a wild goose chase. No one holds responsibility. So it has a clear implication for accountability. The second problem is, this is Professor Chatter mentioned already briefly, is with the public consultation process. Now, the public consultation process, and I personally have been sitting through some of the public consultation process, in fact, it has become a matter of a cursory fulfillment of obligation over the years. This is the most important process if someone has to think in today's world, but we know the principles, globally agreed principles of free, prior, informed consent. And this public consultation process actually has to do with a lot of global principle as well, besides our own laws and constitutional prerogatives. So, but the way it is held, it's people are called, people are barely consulted, they are just read out certain things, and poor recording of the meeting minutes and anything. And this really leads to a lot of conflict, a lot of community alienation, and even it makes project clearance, once a project is even cleared, it becomes contested even in the post-clearance phase. What I feel largely, if we look into the sequence of environmental regulations in India, the clearance process or the permit requirements actually has come into play as one after another law became enforced. For example, since the Air and Water Act came early on, there was the requirement for this consent to operate and consent to establish. But then came the Environment Protection Act, under which later we had the environmental impact assessment notification, but there was no integration. So if we closely look at all this, and I have highlighted that in my paper, there is a lot of overlap in requirements, and which can be streamlined, which really does not improve on the quality of assessment, but only makes it complex and sometimes time consuming. The fragmented clearance process actually makes a case for then a rushed simplification, which has actually happened with the clearance mechanism over the years. Now, it has helped no one, and it has remained only a matter of contention. And right now in India, we have a new environment impact assessment notification that is revised, a new draft notification 2020, which has been now rolled out and is to be finalized within a month's time, to further tinker with the process without really any improvement from the learnings of the past. What I honestly also feel that the clearance mechanism has a lot to do with the entrenched bureaucratic power that really to think of how it can improve the outcomes when it comes to environment or community interests. It has to, everyone, the forest bureaucracy thinks, I cannot let my power go. The environmental officials think that way, the mining officials that way. So there is no cohesion, coordination, or comprehensive thinking about that. And that has been one of the roadblocks in terms of a comprehensive reform. There is a huge challenge with compliance monitoring even when a project is cleared. There is an extremely poor capacity of authorities to monitor the compliance. Now, each set of these clearances comes up with a lengthy set of compliance conditions. If you look into a standard mining project clearance letter, the EC comes with about a set of 50 conditions that a project proponents must comply with. The forest clearance similarly comes with equal set of conditions, the consents come with. But then there is a lot of authorities and there is an overlap sometimes, and there is a number of authorities looking into the compliance, but they do not have the capacity. For instance, there is only 10 regional offices of the Union of the Environment Ministry, which is looking to the host of conditions that must be complied with. And that is both for the environment and forest clearance. And then the state pollution control boards, whereas really there is a lot of staff deficit. what has made this is that the compliance system has largely becoming a self-reporting system by the project proponent. So whatever the project proponents are putting out becomes, they are supposed to put out a bi-yearly compliance report in public domain, and that is the compliance report, without really any cross-checking going on how well that compliance report is, or is it really fulfilling. The other thing is also very interesting, though a bi-yearly report is supposed to be put out, but if we look into, and I did this study once between 2014 to 2018 for actually 2019 for a 5-year period, it showed that only 30% of iron ore mining projects granted during that period had put out their compliance reports, which were operating at the period. So the point is that not all the compliance reports are in public domain. Now it can be somewhere, but for a person to understand what is the level of compliance, it is extremely difficult to know how well people are complying with the regulatory requirements. So basically then comes the final part, is then what is the way ahead for this situation? And I honestly feel that we really need a consolidated and streamlined mechanism to make the impact assessment process comprehensive. And if I look into global best practices today, of course, impact assessment, I don't think it can be rushed. In India, we have a problem of doing things rushed and taking solutions as end of pipe. It never happens. I always believe that you need to fix things at the front end to reduce conflicts later. So basically, everywhere there is a comprehensive environment and social impact assessment that is largely carried out, instead of a very fragmented process. And in India, we need to integrate the process. We must have a comprehensive impact assessment report, which includes impact on environment as well as its mitigation measures, which includes sections on impact of forest and biodiversity, highlighting the mitigation measures, impact on wildlife, and also a very extensive section on impact on local communities, considering their displacement issues, livelihood issues, resettlement and rehabilitation measures. The basic idea is that when these authorities are looking into their idea of clearances or making a decision on a mining project, they can have the picture in entirety, and the clearance decision can be made on a comprehensive understanding of the situation. This will also reduce time, because if you look into the meeting minutes of this regulatory authorities or the advisory authorities, the Environmental Advisory Committee or the Forest Advisory Committee, there is a lot of time these advisory committees have asked the project proponents to bring back documents, asked for resubmissions, because what has come forth is not giving a clear picture. So we really need to understand that we need an impact assessment that is comprehensive, so everyone is looking at the same thing. The compliance monitoring must be improved. Environmental clearance cannot be, or a forest clearance is not the gospel of truth that the mining is happening responsibly, or the authorities can be absolved of their responsibility to monitor compliance. And this has to be done in two ways. One is we need to strengthen our regulatory authorities. Accountability is a key issue at that level. And finally, there is now a lot of discussion on how to use technology to improve this, because given the vast expanse, we really need to use technology. And I'm sure in this COVID times, as we are going into a new normal way of life, into looking into things, technology will increasingly play a very important role. The other question that, I'm sure will come up is with public consultation. And in the post-COVID times, we can have discussions around this. There's how do you do a public consultation? Because when people were required to engage physically, it was not happening the best possible way. And this is one of the curious cases that I have been thinking, that now that the government of India is proposing this revamping, scaling up mining and everything, how will a public consultation happen when we have this social distancing norms, when people can't gather in large proportions? How will it happen? So we really need to think of that. But clearly one thing is very clear, that the public consultation process cannot be weakened. This will only make mining investments poor. I am very confident about that. It is also important in public consultation processes in environmental public hearing, not just to think of the pollution issues or the impacts, but look into also the impacts on forests, look into the impacts of forest-based livelihood. So I believe that these all stakeholders need to be brought together to have a comprehensive public consultation, just like the way we need a comprehensive impact assessment. Finally, we cannot have a single project assessment all the time. The number of clearances that is coming up, and we all have lost track over years. Actually, we don't even know how many projects are coming up and being cleared unless there is a dispute and we read it in media. We really need to go through a process of planning. And the National Mineral Policy 2019, which came actually as a follow-up of a Supreme Court order in 2017 looking into mining disputes of the country, has in some ways mentioned this issue. It has talked about introducing zoning in a way of delineating go and no-go areas. So basically to map the areas of mineral-bearing areas in a way that where mining cannot happen at all, which are typically maybe rich in biodiversity, which are rich wildlife habitats, and where mining can be happened and how. So we really need to think of going ahead with the zoning mechanism and that kind of assessment, which will in fact streamline the process. We also need to think of a regional impact assessment, because one mining project isolated, the pollution problems in a mining area does not always happen for one mining project. If you go in a mining area, it has a series of mining projects back to back, and it goes in vast expanses. So there has been a discussion on regional impact assessment long time back. The Supreme Court deliberations constantly speaks of a macro EIA. Now, it has happened when the Supreme Court told it for a one project, it did, but it never became a process in itself, which authorities have really given a thought to. We need to improve actually the administration as well. In a bigger picture, I would say interministerial coordination, because mining involves both the Mines Ministry and the Environment Ministry has a key role to play in it, as well as we see the center and the state has to, both, all of them has to pay. So we really need the coordination between the center, ministries, as well as between the center and the state. So a horizontal and a vertical coordination will be extremely important, because a lot of time it happens that the central ministry has put out a guideline, but the state authorities are not very clear about it or executing it, or they have a lot of apprehensions about how to go about it. So there needs to be this coordination. And again, I'm going back to court cases. There has been issues of disputes on this angle also, that the state is blaming the central ministry has blamed the state for not doing it, the things right, and not interpreting the laws right. And finally, and I'll stop at this because this is the current topic that has been discussed in the government, is that the Mines Ministry has come up with the idea with having pre-embedded clearance for mining projects before mining blocks are auctioned. Now, this has not been, this is the order has been put out, but right now the government is thinking of doing it in a pilot manner, and to see, in fact, before finalizing on it, how it plays out. This is because that what the dispute, and this has been on representation of particularly looking at the business sentiment, that for whatever reasons, for administrative reasons, for dispute matters, the clearances take a lot of time. And somehow once someone now is auctioning, now India, auction mining areas. So once you have put that investment into auction and auction bids are very, very high, what is the certainty that you will get a clearance? And if you don't get a clearance, then actually you are doing a bad investment. So to boost that business sentiment, there is discussion of pre-embedded clearance, in which this government will in fact be responsible for obtaining most of the clearances, except for the stage 2 forest clearance, because there is some money component that must be paid before the company gets a stage 2. And this is the key discussion process. And with that development, I leave to now the discussions, and I'll end my presentation. Thank you.
Thank you very much, Dr. Banerjee. That was it was a tremendous learning experience for me. I hope everybody can hear me okay. We have a few minutes before we will open this up to questions. And I'd like to just make a few comments about the Canadian setting And what I found really very compelling in both presentations is a number of the shared experiences or shared challenges, but we always assume everything is different everywhere else. And sometimes it is, but then there are these points of similarity which ring for us, I think, for people in working in Canada. As you might know, the federal government in Canada has recently brought in a new Environmental Assessment Act. Well, it's actually called now the Impact Assessment Act. And it's an interesting document because some of the other provinces have moved to align their provincial level environmental assessment processes with what the federal government is doing too. We have a setting where we're usually about
We've lost the voice. Dr. Hanna? Shrestha, are you able to hear me?
Yeah, I can hear you, but I can't. I think we have lost him.
Yeah, he must be connecting again.
We have lost Dr. Hanna, unfortunately. I hope he will be able to join us soon here. I will probably go right into questions that we received from our attendees. And the first one is, the high price bids on India's recent iron ore and coal auctions. Do you think this would lead to miners cutting corner with the requirements of social license? While India's permitting process is complex and time-taking, India's regulatory process is known to be relatively lax. Would the high-priced auctions further encourage exploitation of the lax regulations?
Olina,
I think, okay, we lost you, so.
Thank you, Kevin. I just asked a question here from our.
Yeah, can you repeat it for Kevin so that he knows which question you are asking, because there are multiple questions there.
Kevin, so this is question number 3, is a high price bids on India's recent iron ore and coal auctions. Do you think this would lead to miners cutting corner with the requirements of social license? Can you see that?
Thank you very much.
Yeah, Kevin, would you like to add anything to this?
No, I think it would be great. I've lost my time with comments because of that bit of a technical glitch, but I seem to be back now. So okay. I think we should move right to the questioning.
Okay, so you see, this question, particular question, is important, and I will what I'll do is put a context to this, and then Shrestha would take the second part. You know, those who are not aware of the Indian mining strategy, or how so this is, whereas the presentation that was made was post-lease clearances on environment, forests, and social license. This question deals with what happens prior to the lease is granted. So most of the auctions that have taken place since 2015 have been on the basis of an auction being done rather than first come first served, or so the auctions have been sometimes extraordinarily high, which means the auctions have been to the extent, and this would surprise you, Kevin, it can be as high as 150% of the value of the reserve, sometimes 200% of the value of the reserve. So that is the way the auctions have taken place, and this is a valid question. So if the mining company is ready to pay such high premium on the 200% of the reserve value is being quoted, and then on top of that there are multiple taxes and royalties being paid, the question is that, do you think it would lead the miners cutting corner? So I think this is a very perplexing and complex thing, that the way the auctions have taken place, we are mindful of that, and we are also commenting on that. one more thing I would like to add to it, and then hand it over to Shrestha, is that when the auctions are being done, there is something that all the audience should know, that with the recent set of reforms that the government of India has introduced post-COVID, there are 5 different sets of tranches of reforms that have been introduced. The tranche 4, that is part 4 of the reform, deals with the mining sector, where there is this distinction between the captive mine and the merchant mine has been done away with. So many of the high auctions sometimes are done by those companies which are the captive miners. Probably this will put an end to that. And obviously, when somebody is ready to pay 200 times, twice the value of the reserve, there are doubts that there would be cutting corners on the social license part. And Shrestha, you can take forward the social license part from here. So I just wanted to introduce the first part, because many of the listeners might not know about the auction system in India. So over to you, Shrestha.
Yeah, I mean, I mean, I guess it's just a common business sense, which automatically makes us infer that if someone is paying a high price to get a mine, of course they will try to maximize, cut costs somewhere, and it will compromise on their environmental performance, community commitments, and so on. But at the same time, I think if it's a smart business, and I would say intelligent business, it's also important that, as I said, that getting a mine or getting a clearance itself is not an end in itself. And the maximum number of challenges that have come for a mining project also happens a lot of time when someone starts operation. And today, I feel that a lot of mining companies, and this is largely for coal mining companies, it happens, is that there is operators, it works through mineral development agreements with private operators. And for example, Coal India Limited does not, or their subsidiaries do not operate their own mines. They give it to some private developers who work on that. So that's how they're getting away with. But for instance, if a mining company really has to function in a region, I doubt, unless you really do violations of environmental and social conditions, it really need to be mindful till what extent you can cut corners, because that will only hurt your business in the long run. So and then it will go to court. I mean, for example, right now there is a matter pending in the Supreme Court with respect to Goa mining. There have been cases of Orissa mining. I'm talking of the biggest mining states in this country, the Karnataka, where Supreme Court has put a complete ban on mining operations given environmental and social violations. The question is, do you want to get into that? Now, if someone risks of getting into that, then it's okay that to cut corners. But if you do not want to get into that, then I believe that a mining company really needs to think that how much they can cut corners. But at the same time, I believe, and this is the economics part of it, that this auction must be regulated, because in some ways the auctions are also actually going through very high bids, and it can raise questions about all these major ideas we have with respect to mining in terms of intergenerational equity and all these major ideas. Like, if you are selling with so high price, then you are actually, so I believe we really need to, both the government as well as the mining business, both has to think about it. And it is something to work on. I mean, I don't work with respect to auctions, but I believe that this is one area of work and research that has to be done. That can it go on, and how much does it really jeopardize this social and environmental responsiveness of a mining business?
Thank you very much. I want to go to a question which I think is really interesting given the context of everything we see in the world, certainly living in Canada and looking what's happening in our neighbor's country. There's so much conflict. So the question is, in many mining areas in India, people were reported to be not responding to the environmental violations and the associated side effects in their lives due to the fear factor. Fear of losing jobs in the mines or the opportunities for jobs, as many people in such mining areas may be poorly educated. Will the rights and liability regulatory mechanisms or disclosure mechanisms, can the regulatory mechanism for mining be improved? So I think it's fair to say that the way the fear factor is described here, we sometimes see that even in the Canadian setting. So I'll go to Dr. Shada first, and then to Dr. Banerjee to comment on that.
Yes, I think this I can read the question. This is a very valid question, that how far the affected communities can go as far as the if the commitments by the mining companies on the social license are not being fulfilled. Here, I think it would be something similar in other countries as well. It's not just a question for India. What I would like to comment on this is that there should be, as Sreshta has already pointed out, there has to be a coordinated effort between the mining companies and the government together. And the principles have to be agreed upon from the beginning, and they should be taken forward. As there is a lack of number of regulators, Sreshta pointed out that the regulation is not being done in the way it should be done. So my answer to this question will not be a one-liner, but I think it will be something similar to the set principles that ICMM or maybe the Mining Association of Canada. Similarly, I would like to have the industry association, that is FIMI, Federation of Indian Mining Industries, which has a sustainable mining initiative built into it, see to it that the mining operations are not only auditable by the government, the mining operations are also audited by the mining FIMI or SMI, and that is the way forward to this, because a single individual or a group of individuals will always be in a fear when they protest against a big person. So I think that the answer to this is quite complex, and the answer to this is that we need to, and that is what this research we are building at Brookings India is about, that bring together the, it's the style in which I understand Mining Association of Canada is doing. So any complaint that goes to the Federation of Indian Mining Industries or mining initiative, this sustainable mining initiative, should be looked into carefully, and that is the auditing needs to be done at both ends, by the government as well as by the industry association. I'll stop here, Sreshta, and over to you.
Yeah, I mean, I guess the problem in the mining area, and it's two things, as I pointed out, that many of the major mining companies do not operate in the mining areas themselves anymore. And it is done by private operators who, if you go to, I'm giving an example here. So if you go to a big mining area in Jharkhand, you will find, and it's a publicly operated mining area in Jharkhand, the company doing the mining operation is a private company, which is from some other state, because they don't want to be accountable to the local people. And there is that is one issue that must be resolved, whom to hold accountable. The second thing is about the community fear and all this. Yes, that is there, but the challenge is, that's why I told that we need a system both at the front end, and once a project is cleared, we need to fix the system. So why should a mining company be violations come in two ways. First of all, if a mining project is allowed based on faulty documents, on poor settlement of rights, on poor understanding of pollution issues, the environmental impact assessment report is poor, then that leads to community alienation, but they can't voice their opinions because they're, so we really need to fix the assessment process in the front end to reduce dispute. That's number one that can be done. The second end of the problem, which somewhat Professor Chatter was referring to, is improving the compliance monitoring. There is no alternative to it. And how do you do it? I mean, auditing is fine, but the point is that and the new environmental impact assessment notification that I have right now mentioned has has introduced certain penalty mechanisms if someone is not complying, and there are graded penalties that have been outlined, but still penalty has been really poor, and unless there is very high penalty for non-compliance, which must be monitored, then there can be. But at the same time, I mean, the authorities themselves need to look into fulfill their jobs, because if I'm knowingly giving clearance to a company, knowing that there is no authority to monitor or enforce the compliance, then I should not be given clearances in the first place. So the government has a responsibility to build on the monitoring and compliance, to build in the capacity of monitoring authorities and ensure compliance. But I guess there will be several instruments that has to be come into play to deal with this. And of course, I agree with that there can be fear factors, but this can be the only solution to it for the time being.
Thank you very much. Another question which has appeared, and I think this is really interesting from the perspective of a lot of the work that CIRDI has been doing and what I know of some of the activities of Brookings India. Thank you for your presentation. I'm curious about artisanal and small scale mining licensing in India, and really what is the difference in this licensing approval process. And we often underestimate the environmental and social impacts of this sector too. So I wonder if you could just comment on what that looks like, and I'll pose that to Dr. Chatter.
Yeah, I think I will hand it over to Shrestha.
Oh, okay.
Yeah.
My mistake.
No worries.
So basically, the small scale mining has been largely left unregulated for a long time, and what you were referring to as artisanal mining. So basically, in very small scale leases involving it has not required an environmental clearance or an environmental impact assessment for the longest time, because it is largely regulated by the state government. And the idea of this mining is, the small scale mining is basically to provide an economic activity to the local community. So, and these are very small miners. They don't have the money to carry out an impact assessment or to do with various processes. Now, the problem with that happened was it led to a lot of illegal mining over the years. And particularly given the construction boom, which came, the biggest controversies came in fact from illegal sand mining, which has to do with the construction sector. What was also happening is, because as I mentioned once, that below 5-hectare leases did not require an impact assessment or a clearance, so people were submitting proposals 4.9 hectare, 4.95 hectares, so breaking it into small proposals and leases. Now that created a havoc, and what then Supreme Court in fact intervened through a very important judgment in 2012, when it told no, this can't go on, and there must be a clearance mechanism, properly regulated mechanism for mining projects. And then in 2013, the National Green Tribunal also put actually small scale mining on hold in the entire country unless they had an environment clearance. Following all this, so in 2016, the government of India, as I was telling, the district level authorities, brought out a notification under which it said that irrespective of the mine lease size, now everyone needs to get a clearance. What government is also promoting, and it is yet to happen to a proper level, there are issues with how it is being executed over the past 4 or 5 years, but basically what it is saying is that it is encouraging cluster mining. So basically, if you have a lot of small leases, and if 2 leases are within 1 kilometer of each other, so you take them, consider as a cluster, and you conduct environmental impact assessment of the entire cluster. So you look at the cumulative impact. So the cost is not borne by a single small miner, but then because you need to enforce compliance, but the clearance will be given to individuals. But the impact assessment, so that everyone collectively can pitch in and get the impact assessment done. So taking all that into account, the government has pitched that. The second important thing actually to regulate small scale mining, which has been proposed, is to develop the district level survey report, which is a good idea, which was being, that for every minor mineral, there will be a district level survey report looking into the capacity, particularly it came with riverbed mining. So what is the reverse replenishment rate? How deep you can go into mining? And Geological Survey of India had guidelines for all of this. So that became integrated into that. So that's how small scale mining got regulated and illegalities, particularly in terms of environmental impacts of it. So if that answers the question.
Thank you very much. So there's some really interesting dynamics there about the role of what we might even call class assessment in our setting, looking at repetitive, predictable activities and then assessing them together and operationally, which I think is a really interesting approach to that scale of mining. I just want to go back to our questions here from our audience. One is, do you feel environmental and social clearances should provide prior to auction? The question is raised on the grounds of the present situation in the Dinning Patkai area in Assam. So there's a nice case-specific question there, and I'm wondering if either of you are familiar with that.
Yeah.
Which question is this? I am not.
Do you feel that environmental and social clearances should be provided prior to auction? The question is raised on the ground of the present situation in the Dihing Patkai area in Assam.
Right. I think what I said in my introductory remarks, I would like to repeat once again, that the National Mineral Policy has clearly mentioned that the leases would be given with pre-embedded clearances. Now, pre-embedded clearances is a loaded word, and I don't think that I would like to go into a specific mine. I don't have a specific mine lease in my view when I'm discussing that. But what I feel and what is important is that if we leave it to the mining companies after the lease has been granted, and as I think one of the slides clearly showed that maybe 45 to 50 days are given for the consultations for social licenses, my view is slightly different, and my view is that at the end of the day, the government is also earning. The fiscal situation is becoming better with more royalties and more auctions. So there should be a continuous way of looking at, whether it's a brownfield area or an area where there is potential for greenfield. The assessment of various kinds of issues, whether they are environmental or social, are also government's responsibility. And it should not be left to the mining company that the lease has now been granted, go get the social license. I have a point of difference there. So my view here is that it is a continuous process, which I might call a clean mining campaign, which is a part of basic education of potential mining areas. As I saw one of the questions is saying that, the mining areas in India are slightly different from when we talk of the potential mining areas in Canada and Australia, because they are the most densely populated. And you know it, but those who don't, the poorest of the poor are living on the richest mining resources below them. And therefore, I think it is the urgent need for the government to be fully involved. And the question is very valid that part of it should be pre-embedded when the mining lease is awarded. And it is equally the responsibility of the government as it is of the miner. And I stop saying when I say that those 45 days probably is too less to educate the local people there. It should have been a part of the education process. I think I'll go to the extent that it should be a part of the school education curricula of those areas where there is potential. And we know that in the coming years, there is going to be mining. So that the people are aware that how good it can be despite being multiple negatives in it. So I'll stop there, Shrestha.
Yeah, I mean, honestly speaking, I'm just thinking of this pre-embedded clearance mechanism, because there are pros and cons to it. And as I said, that we really need to think through how it will be rolled out. One of the thing is that what it is clearly meaning is that, see, this pre-embedded clearance idea is clearly to boost business sentiment. That is very clear. And it has been brought out with that logic. Now, the question, if we think in terms of environment and community issues, now, it is, the point is that how well the impact assessment is being done, and then it is auctioned. Because to me, if an impact assessment is done well and we have an accountability ensured at the front end, then we really need to think through. As I showed you that in the forest clearance process, in fact, it was already done by, not by project proponents necessarily, it was government who was taking forward the proposal largely. So what in this is also what government is, the onus is put back on the government to procure the clearances, and then you auction the mining blocks. That is so that is one important thing that can happen, and maybe it will improve, but I really need to, because it's still that these things have to be outlined very well, and we need to understand that what responsibility then needs for the mining company. Because what another challenge is also that how do the people ensure the accountability of the government? I mean, how will the government do this public consultation processes in the process? I mean, what will be the level of engagement? Because until now, we knew the way of one project, people are informed. Now, do you want to make them understand, 5, because the way they're thinking of is doing 5 chunk blocks in a go. So now that is a huge scale. And in a post-COVID world, as I already said, that I'm not really sure that how these mechanisms will be enforced. How will the public consultation or public engagement be carried out for 5 mining blocks? And if a big 5 mining blocks I'm thinking of, it's a huge area. It will involve a lot of number of villages. So how do you bring them together? How do you engage them? The impact assessment report, but if this done, maybe it will require a regional impact assessment report. You can't rely on an EIA that we have currently on a single project, because that does not fulfill your condition anymore. So really these mechanisms have to be thought through instead of rushing into it, and I personally would like to think through it and work on it a little bit more further. Yeah, that would be my question. I'm not really giving any conclusive answer as of now.
Thank you very much for that.
Yeah, very honestly.
Kevin, I would just add to it is that when one is thinking of, am I audible?
It's a little bit difficult, but I think we can hear you now.
Maybe I think I'll stop my video because there may be a bandwidth problem at my end. Now, what I will like to add to it, that this is a process that is being thought through. It does not mean that the particular mine lease that has been granted is fully loaded with all the licenses being cleared. The limited point that I'm making, and I'm again making it to the government, is that there has to be, it's not for a particular one mine that I was talking about. I said a general process of educating the local people about what mining is about and what good it can do to them. And in the long run, as intergenerational equity issues are all there. So the limited point I am making is that I don't feel comfortable with 50 days or 45 days, even if it is no COVID, that the people can actually respond to such a big project that is coming into. So a process of continued educating the people about what mining is about, so that those 45 days they spend more fruitfully, because they had the early knowledge of what all mining does to the region. And obviously, we do know that that particular region has a potential for certain minerals. So the education is done in that context. So that was the limited point I was making.
Thank you very much. I noticed that we have about 10 minutes left in our session, so I'm going to ask both our presenters to keep the answers really to the point. There's so much of a rich discussion we have here, and we'll try and squeeze in as many questions as we can. One of the questions which is interesting is, well, they're all interesting, but this one, so you were suggesting that complaints about mining company violations should be audited by industry associations. Wouldn't a social audit be better? Do you think India's FIMI can recommend an independent social audit in India? And the reason I find this intriguing is this question about self-auditing and self-review and self-reporting is one that is problematic in the Canadian setting as well. So I don't know who wants to start with that one.
Sorry, Kevin, what is it about social audit for mining?
The question is, are you suggesting that complaints of mining company violations should be audited by the industry association? Wouldn't a social audit be better? And do you think that the setting is such that it could allow a social audit?
Yeah, I think there are two parts to this question. One, if the social audit is the way the government should be doing, what regulation or regulatory authorities are doing, because National Mineral Policy has a clear mandate on establishing an integrated body that would be looking into all these aspects. So I'm fine with the social audit. The limited point I was making in when I said that, like the other industry associations elsewhere are doing, the industry would be taken more seriously if it itself tries to kind of listen to what the problem is and give some mandate or value judgment on that. But I am very much for the social audit that needs to be done.
I'm going to jump to another question here. Thank you very much for that. And this is something that comes up a lot in debates about projects and project approval. Why is there no discussion about the good from mining, like the contribution to GDP and the source of betterment for sphere of life, revenue to the state, a lifeline to areas for supporting education, hospitals, and so forth? So we do focus on the negative. Is this a question of trade-offs or balance or reimagining the idea of sustainability? And I'd invite you both to comment on that, and I might start with Dr. Banerjee. We spend too much time on the negative.
Yeah, I'll just be very brief. So, see, the basic idea is, yes, I agree, and if that's why in the very beginning I told that I personally believe that mining can't be wished away. And in many respects. And I gave the example even of renewable energy for that matter. That's the reason. The question is that I don't think that mining is always projected in a bad manner. And the reason there is a reason that there are issues with mining having a negative connotation. And it has come historically. It's not that someone had something against it. Of course, there are always, interest groups which can paint a good picture or a bad picture. But even if I think of the bad picture, there is a reason it has come up. But at the same time, I believe that there are various groups or people who also understands that it is important. It is important for various reasons. And the question I think here is the gap in understanding about mining in India, and this is my experience with India's environmentalism a lot in some ways, that there is a disengagement between the various actors. So there, and I guess it happens also with researchers in Delhi. I always say that, you know, there is no cross engagement between state, between mining companies, between the community, being researchers, being advocates, being policy people, and so on and so forth. So this idea that always mining is painted in a negative picture is not right, nor is the idea that mining is a win-win. I believe that there are gray areas which has come up in the time, and we don't know this because we don't engage. And once we engage, because I am telling a very personal experience from my side, is that once I was going through Chhattisgarh and I was coming from a South Basta region, from the iron ore mining areas back to the town, and the guy was driving the car, and he's from that region, and he told that, you know, some mining company where they are operating, it was a private, they built this and I have got this road and now I can commute and so on. So it's not always negative, but the point is that that's why public engagement is required, because there have also been roughshodding, which we can't just deny. So we really need to be mindful. That's why I'm very careful about, you know, saying that it's good or it's bad. The question is, I feel that it has constituted an important component of the economy. It is an important component of many technology you were using. So how do we improve its governance? Let's just stick to that instead of painting it with a very great brush, or, you know, just demonizing it. I don't think either taking a side is really a good idea in any, because it's a business. There will be trade-offs here. I mean, realistically there will be, and the entire purpose is to fix those trade-offs, minimize those externalities as much as possible.
Dr. Chadha?
Yeah, Kevin, I think the question is more in the sense of value addition to GDP and the issue of more revenues for the state. So there's only one answer to this, that yes, if you want your country to have the food processing sector succeed, you must have your agriculture flourishing. If you want your country to have the manufacturing succeed, and particularly the post-COVID scenario of the fractured value chains, but that's a point I can come to later if there is a question. But definitely, mining adds value to GDP. Mining has got backward and forward linkages, and mining is obviously adding great value to those poor people who actually need the jobs, who actually need the hospitals, who actually need the schools, which under the social licensing in the best practice case, I think they would get. So yes, mining is important to that extent that without having a good mining mineral structure that we have, we probably cannot proceed to the manufacturing, particularly of the manufacturing of the kind that we would see in the new century.
Thank you.
Kevin, I'll just add one quick point here. You know, this is a study which is very poorly done in India, that the question about mining and jobs and employment, because it's a big challenge. If we think of course, in a mining area, mining comes up, industry comes up, some jobs are created. But two things also happen simultaneously. One is we are increasingly going into mechanized mining. So we have the productivity increase, but we don't have the job increase over years. It has actually been going down. So that is one of the issues which comes out from the local levels, and which is a very pertinent issue. The second question is, in a mining area, mining is not the only activity happening. Large majority of the community in any mining districts, 50% are dependent on agriculture. And there are also forest-based livelihood. Now, the moment the pollution issues are not taken care of, the forest diversion issues are not thought through, the community rights are not settled for these forest areas, these livelihoods gets affected. If you go to a mining area and go to the agricultural field, there is red water. So the farm productivity goes down. There is a lot of this kind of impacts, which is not related to direct job creation, but indirect these effects, and that creates a lot of challenges with respect to what the mining brings to a region. So I guess we really need to deal with these issues in a more complex way.
So I'm going right to the end because it actually summarizes a lot of the themes that have come up today. And I apologize to everybody for not getting through all of the questions. Accountable mining, question mark. What about the consent of mining affected communities? So what would, and I ask you both for just a quick closing comment, in your idealized regulatory process or community consultation process, what would accountable mining look like in the Indian setting? And I'll start with Dr. Banerjee.
I mean, I personally would say that accountability issues, fundamentally lies who you are accountable to. And I believe that the fundamental accountability has to be with the people who are most affected by it. And so accountable mining, the fundamental thing with accountable mining is the consent mechanism. And I believe that the person who asked the question has already pointed that out. That's why I said that under no circumstances, your public consultation process, your Gram Sabha consultation process can be shortened, can be diluted. I would say diluted. And that builds in the accountability. So you have taken the people's confidence to go ahead or not go ahead with the work. That is number one, accountability. So, and the second accountability, of course, we talk of is financial accountability, which has to do with authorities. But this is the fundamental authority or accountability, I believe that the question was, and I completely agree that that level of accountability needs to be built in. One question was about the social audit. I would just say, I mean, social audit is basically audit by the local community in a random way, whether how someone is. It's basically a performance audit independent by the local people. Now, if that can work, it's great. In India, we have tried it under the Mahatma Gandhi Rural Employment Guarantee Scheme we have. But the way social audit goes is not best. But yes, in a country like India, where you have a decentralized governance mechanism, you need something like that to improve accountability. I believe in that. I mean, we have a lot of problems with our local level institutions, but then our laws are also developed around that. I always say, then either India should think of not designing the laws which actually gives them rights, not have that pretense, or if you have developed those laws, then you must actually be truthful to it. So I'll stop with that.
How do we measure consent? Like, how do you know that a community is given consent?
There are mechanisms of verification. So basically, there are paperworks that are there, the way the consent mechanism goes. But the dispute has been that all these consents are a lot of time actually fabricated. They're not the real. People have been found that's a big. The fundamental issue with forest rights is that. Even I personally looked into the cause that the person doesn't even exist, and but the consent is there. So it's not. These are very difficult questions, and I know that there are fantastic groups at the grassroots level who are local, who are working with people there. But the challenge is extremely complex because these tribe people live in small areas. The penetration level is very high, so there must be some level of thing from the government to ensure that the forest rights, settlement records, and all these kinds of concerns. There are other types of things also, but I'm just giving one example, are really done. There are ways. I mean, paperwork is there. There are levels of verification, but it's complex at that level, which doesn't happen.
Dr. Chadha.
Okay. Yeah. Not more than. I think with this issue we discussed somewhere in between when the other questions were coming, and accountability has to be surely to the to the agreements that they have already made. So there is a set of agreements that they have made with the pollution authorities, the environmental government. So they are accountable for that. The mining companies are, and they are also accountable for fulfilling the promises that they have made to the society. So accountability is a two-way street. One is to the regulatory regime on which what the topic of discussion today is, and on the other hand, to the local communities to who they are accountable for what they had promised, are they giving back? And so there are two levels of accountability that both need to be met. And I think it is in the interest of the mining companies themselves, because a better accountability, a better meeting with the promises that they have made would give a better scope for the future of mining, more investments and new investments in mining. I think I'll stop there.
I think one thing I would touch on is, like, not all companies are the same. There are corporate cultures. They have different ways of looking at the world, operating it. We tend to think of the industry as being monolithic, but it isn't. I imagine it's the same in India too. It just isn't. Mm-hmm. So we have companies that are easy to work with, good to work with, have a progressive vision, and others that just aren't there. So there's challenges in that respect, I think, depending on who the proponent is and who the operator is.
Absolutely, absolutely. I mean, if you go, I mean, there is a lot of confidence in public companies and I'm talking this again about coal mining. But I mean, you'll be surprised to see that the private operators like Tata, in sometimes has those areas are much better managed. The communities are much. So yeah, I completely agree with you, Kevin, that there is a shade into this. But clearly it's certain things. But I mean, in any governance issue, we need to take into that there will be good players and bad players. So we need that. The administrative mechanisms to be strong, so that bad can only go so much bad, or best can come out. So I believe that's the reason we need good governance.
Yeah, it provides that constant operating guidance. Yeah.
So Kevin, this is not specific to mining. Let me clarify that. This would happen in any developmental project. So we should be mindful about that. Mining is also one of the sectors, and to color it with something without going into the depth of it would not be the right thing. So I think we need to be watchful, we need to be mindful, and we need to see to it that it is in the company's interest themselves to have met their promises and move forward.
Yeah, and I think this is it is where the industry associations can play an important role in providing not just guidance, but really a statement of expectations for people in the industry to be able to follow and to meet. Even if it is voluntary, that can still be quite powerful in some settings. We're at our time now, and I want to, first of all, apologize to everybody out there if I did not get to your question, but I do encourage you to reach out to our colleagues through Brookings or through CERDI here at UBC. And if there are any specific questions about the presentation files or problems accessing that, please do reach out to CERDI to get that sorted out. This topic is far too large and interesting and complicated and important for us to have answered and solved everything in the very, very limited time that we had. I want to thank our guests in India for joining us in the evening. It's, again, very early in the morning here in BC, but I've had lots of coffee, so I'm good for the day. I certainly see so much overlap and parallel to some of the experiences in the Canadian setting, while of course recognizing that there are great regulatory governance and just geographical differences too. But it's very instructive for me as a researcher based in Canada to find that there are these shared challenges and constant and ongoing experiences. I noticed one of the people joining us today had commented on the lack of really demonstrable site restoration, reclamation, good follow-up, and so forth. And I was thinking, yes, this is something that we see as a challenge in this country too, that there are probably not that many good recent examples of effective site reclamation. I think there's some very promising work being done, but so much more. I think it's fair to say that we'll all get better at this too, but the technology and the opportunity that is provided, well, that's been provided to us out of necessity to deal with a global crisis, has created opportunities where small gatherings like this are possible, that we learn how we can interact quickly over long distances and know more about each other. So I want to thank my colleagues at CERDI for inviting me to participate today and have the opportunity to meet our colleagues in India. Thank you, everyone, and I hope you have a great day.